But we're going to start with Professor Alana Cattapan, who is the Canada Research Chair in the Politics of Reproduction and an Assistant Professor in Political Science at the University of Waterloo. She studies gender inclusion and policy related to reproduction, and she's a former graduate of this university. And it's fantastic to have her here presenting. So Alana, you have 15 minutes. The presentation is called The Receipts, Reimbursing Egg Donors in Canada. Oh yeah, sure.
Yeah, it's a little weird. Michael was my prof when I was a baby academic. He didn't say it, but it is like lovely to be back here. So it's so wonderful to be here with you all, and I'm so pleased to be a part of this panel. The work I'm going to share with you is one of the many papers coming out of a broader project I've been working on for the last few years, together with Katie Hammond and Vanessa Gruben, that focuses on the experiences of egg donors in Canada. And I just want to give a shout out as well to Sarah Seabrook and Anya Johnson-Poon, who are here, who did a lot of the research for this project. So the work I'm going to share with you today comes from interviews we did with 53 egg donors who provided their eggs at a fertility clinic in Canada since 2004, which is the time that the Assisted Human Reproduction Act passed. The slides will come when they come. It'll be fine. Okay, it's okay. They'll arrive. Oh, there they are. See? Just be patient, I guess. And I think this is how you advance them. This thing? Yeah. Okay. Green arrow. Oh, green arrow. Got it. Okay. Green means go. Okay. I have a PhD, I promise. Okay. So that's when the federal law on assisted reproduction passed, was 2004, and everybody we interviewed had donated since then. And what we found is that donors' knowledge about the law, about what they're entitled to under the Assisted Human Reproduction Act, and their experiences with legal contracts and egg donation and agencies, what they understand the law to be, is there's a gap between what they understand the law to be and what the law is, and that information is often mediated by lawyers and agencies. I'm very glad to be going right after the panel on surrogacy, because I think it continues the conversation. So again, a significant gap between what the law and regulations are and what egg donors are being told by agencies and lawyers that they're, oh, of course, what they're entitled to. It's just water, we're okay. Okay, so this means that egg donors are being recruited and engaging in egg donation under false pretenses, and that they're actively being misinformed about the circumstances of their donations. And I'll give a little caveat here that reimbursement and potential payment is not the most important concern articulated by the donors we talked to. This isn't something that they always brought up. It was in many cases what might have drawn their attention to an Instagram ad in the first place, but most knew quickly that it wasn't going to mean much money if they donated in Canada, and that's not why they went through with the donation. Egg donors, when we asked them what they really wanted to talk about, it was being treated with more care, with their health and well-being being taken more seriously. But I'm going to talk about money because this is one part of a much larger project that focuses on donors' experiences. And their experiences with payment is the thing we're often asked about. And this is one of their experiences. Okay, so very quickly, I'll talk about the history of reimbursing egg donors in Canada, the study, how we operate under false pretenses in Canada, and then a few notes to wrap up. So the story I want to tell you is something that we've already talked about today, largely that the Assisted Human Reproduction Act prohibits payment for egg donation, but it does allow the reimbursement of expenses if it's allowed, and it's allowed if it's in accordance with the regulations. But you can see like the gray area creeping up in 2004 because there were 15 years of relative inaction. There was no regulations on which to like allow it to be in accordance with the regulations. So in 2019, the government of Canada did create some reimbursement regulations. There's a list of expenses which can be reimbursed to donors, identifying which issues, which ideas can be reimbursed, and which would be therefore excluded because they're not listed. But that 15 years between the time that the law was passed and the promulgation of the regulations coincided with a huge boom in assisted reproduction between 2004 and 2019. That's a pretty important time in assisted reproduction. And so a lot of us have documented over the years that this has meant that in that 15 years, the lawyers and agencies working in the field knew people couldn't be paid, but they could be reimbursed, and they sort of developed their own practices in the field. So when the reimbursement regulations came in 2019, it was, and Dr. Carsley has documented this quite well, a codification of existing practices. So the range of things reimbursable under the new regulations effectively put into law or into regulation what the agencies were already doing. So one of the questions we were interested in the study was, what were donors' experiences with reimbursement or payment, however they experienced it? And further, how do they understand their experiences in relation to the law? So as I said, this comes from a much broader study of egg donation in Canada, projects called Ova Obscura, and it focuses on amplifying egg donors' experiences. And again, we interviewed 53 egg donors who provided their eggs at least one time in a Canadian clinic since 2004. We followed a semi-structured interview guide. Each interview was conducted over Zoom. They lasted between 45 minutes and 2 hours. I'll say they mostly lasted close to 2 hours. They were audio recorded, transcribed using AI software, corrected by an incredible team of RAs, like so good. They're so amazing. And then they were coded inductively and then put into a variety of tools to interpret the data. So we have data collection tables, narrative summaries. I'm happy to talk more about my methods. So again, 53 participants, but they represented around 130 cycles of egg donation total. Most donors actually only donated once, but some people donated a lot of times. And some people actually didn't know how many times. So it's around 130 cycles. Like 13 plus, I believe, was the highest we heard. They were located across the country. One now lives abroad. Most of the people were in Ontario, BC, Quebec. And about a quarter of participants identified as having a background other than white. About a third identified as something other than heterosexual, but they generally map on to sort of expectations of the Canadian population and the ages we would imagine for people donating their eggs. So I won't spend a lot of time with this study because I want to get to the findings. And what I want to highlight pertains to the 30 or so egg donors in the study who worked through agencies at one time or another, and focusing in particularly on people who engaged in donor cycles since 2019, when we knew the regulations would start to becoming in force. And what I want to highlight from what we heard from donors is how they're being told about the law, how they're misunderstanding the law, and the kinds of things that would be available to them as donors. So a few of these false pretenses. So donors were told that they could be reimbursed for their donation, not for the reimbursement of expenses, but for the donation itself. This is rarely framed, at least in the initial conversations that donors have, in terms of reimbursement of expenses, but there it is. So the mention of expenses is rarely explicit in advertisement. There's simply a promise of reimbursement for the donation, as if, again, the donation itself is what's being compensated. So here's an Instagram ad from a particularly prominent egg donation agency that features in our study. And here the language of reimbursement is there, but it again says for the donation, no mention of expenses. And this is true in other Instagram ads. We see no mention of it's actually for expenses. The language of reimbursement is used, but it comes across as payment. And I didn't include this video that I was looking at yesterday because it was hard for me. I don't have the technological prowess, but there was promises of up to $8,000. And it was a discussion of it's hard times. You might need the money. You can be reimbursed up to $8,000. And so the selling, even using the language of reimbursement to stand in for compensation, happens a lot. And the donors we talked to knew that it was illegal to be reimbursed for the donation itself, but they could be reimbursed for legitimate expenses and understood that to be a workaround of the law. So I'm going to go back. Can I go back? Oh, okay. So the other thing they were told often is that there's a cap on the amount that they can be reimbursed for their egg donation. So the regulations under the Assisted Human Reproduction Act that were passed in 2019 do not in any way set a cap on donation. The 2019 reimbursement regulations do not do this, nor does the Assisted Human Reproduction Act more broadly, but intended parents don't have to reimburse. It's entirely voluntary. There's just a list of things that can be reimbursed. But agencies and lawyers are laying out in donors' legal agreements how much the intended parents can expect to spend on reimbursements. We would expect them to do that, some clarity around what can possibly be reimbursed when they write these legal contracts. So donors are told by agencies and lawyers that a specific amount is set for what they're able to claim. And that gets codified in the legal agreements. So donors are told that they can claim up to $5,000, sometimes $6,500, sometimes $8,000, but that's the maximum amount they can claim, no matter what their actual expenses are. Esther, and these are all participant-selected pseudonyms, was a very savvy donor. She has provided her eggs 5 times total at the time that we talked to her, most of those since 2019. And she was very clearly under the impression that the law in Canada was that people can be reimbursed up to a maximum of $5,000. Others understood that $5,000 was that cap. Some other people had a different sense of the number, but usually in the last 5 years or so, people thought at least at the time of their first donation, $5,000 was the maximum that they could claim expenses for, again, no matter what those expenses actually were. And what the idea of a cap means too is that if donors exceed that amount, as Isabel mentioned in the last session vis-a-vis surrogates, they can't get more. So we definitely heard from a few people who felt that they were out of pocket because they did have legitimate expenses that went past that $5,000. But the agencies and lawyers certainly know that this is not always about reimbursement of legitimate expenses, because while there is a sense that there is a cap, whether or not there is an actual cap, which certainly isn't, donors are told that if they are successful in their first donation, when they come back, that they can ask for more money. So Anne, who first donated in 2018, and then again in 2020, recalled being reimbursed $3,000 for her first donation. And then she was told when she was recruited to come back that this time she could claim $5,000, even though she had trouble finding enough receipts the first time to get up to that $3,000 mark. And Anne said, they said it gets higher because essentially they, the agency, know that I'm a good egg donor, that I donate lots of eggs. And this isn't the only person we heard say this. The idea that they could ask for more over time once they were a proven donor was something we heard quite a bit. And so what this suggests is that agencies are, and this isn't surprising to anyone, I don't think, not really engaged in the legitimate practice of reimbursing surrogates. The reimbursements codified in the donor agreements are reflective of the capacity of the donor and the understanding that they will be good and productive donors in some way. And what we see too is that the system of promised reimbursement amounts works in a way that the agencies coach donors to fill out forms that are meant to help them reach the reimbursement amounts that they're promised. Coaching of this kind is not unusual. We heard about it a lot. Here is a document that would sort of a sample form that somebody could fill out with examples of potential. This is an actual one somebody sent us from an actual Canadian agency, but it's a sample that leads you to about $5,000. Some donors legitimately just wanted to be reimbursed for their costs out of pocket and thought carefully about what this would cost intended parents. And they probably would have been happy with simply being reimbursed for their actual expenses if the expectation had not been set that they would get $5,000. But this is not the expectation that was set. And we heard about people buying all kinds of different things to meet the amount or find expenses elsewhere. And so this is actually Amy, not Anne. That's my fault. I forgot to change the bit on the slide. Amy donated 10 times between 2013 and 2023 when we talked, and she was super clear on this issue, stating that she would make up receipts to stay at a friend's house, and you could write off everything from the time that you were matched to the time of the donation. And so she would collect grocery receipts for the whole time. She would also use her mom's receipts, and her mom shops a lot, which I love that quote, because there's no way I would ever get to that amount. And I'll just flag quickly that donors and in the donor agreements, there's an understanding that if they withdraw from the donation, that they will have to repay any reimbursements that they've already received and any medical expenses that they've incurred. This is in their legal agreements, even though there are many lawyers in the room. This certainly isn't enforceable, but it was in their contracts that if they withdrew from the donation once things got rolling, they'd be on the hook for any reimbursements. And some of them didn't submit any of their claims or were told not to submit their claims until the end of the donation. And so if they were out of pocket, if they were spending money, perhaps to travel, to do other things, there was a sense that they wouldn't be reimbursed unless they went through with everything. So all of this to say, again, I feel like we've been in the thick of the research for so long. This doesn't feel surprising or new. It feels like so obvious, all of the things that I'm saying. But the clandestine way that payment is happening is kind of the law working in Canada in a strange way. The commitment to the reimbursement of reasonable expenses artificially limits potential payment in Canada because $20,000, $30,000 wouldn't be seen as reasonable expenses. So donors are not largely motivated by money in our study, but some come away with $1,000, $2,000, a small amount. But they're not situations in which they're engaging largely to acquire in Canadian clinics a large amount of money. even when they come away with a little bit extra. The reimbursement regulations, as we saw, we interviewed people from 2004 up right until 2023 who donated. They didn't really seem to change anything, but they did reinforce the idea that it isn't open season on paying egg donors. And so to wrap up, the way that this is working, so I think that it is in many ways a very strained way for altruism to actually kind of be happening in Canada with like little soft dollar bills around it. You know, it's both. And so the way that it's working though might be troublesome for intended parents who are led, as I understand it, to believe that the reimbursement of expenses is actual reimbursement. So they're told that a donor will claim up to $5,000. Well, the donors are told, push it, get $5,000. That money is yours to claim. And the donors we talked to also were clear that they liked that the system was largely altruistic. This isn't uniform across the whole study, but most people were happy with a system that's largely altruistic, but they wanted more transparency about how reimbursement of expenses worked. They knew it was sort of shady, that they were manufacturing expenses or asking their mom or whatever. We have a system in practice that is similar to that of the UK, where reimbursement of expenses is accompanied by a small stipend, but our situation is happening in this covert, very strange way. So as I'll just wrap up by saying, as Senator Mention mentioned before, we could shift this all slightly in regulations to address things that are, to make this all clearer and to make everyone less vulnerable in this experience. So thank you.
Wonderful. Thank you, Alana. Our next speaker is joining us online from British Columbia. Régine, are you there? She's there? Sorry, okay. So our next speaker is Régine Tremblay, who joined Allard Law at UBC in 2017, where she specializes in family law, matrimonial property law, private law, and family mediation. Professor Tremblay is also the director of the Center for Feminist Legal Studies and co-editor of the Canadian Journal of Family Law. Her talk today is entitled, unless it's changed title, I don't think it has, Reproduction and Feminist Challenges, Reforming Parent-Child Relationships in the Civil Code of Quebec.
Today is entitled Reproduction and Feminist Challenges, as it was just mentioned, and it's a bit of a shift. So I'm a multi-jural jurisdiction in which civil law and common law and
The problem is on our end. We're just having some technical
Aboriginal
difficulty. Régine,
Okay.
You're cutting in
Yes.
and out. We're just going to try to correct the technical issue. It's not on our end. Okay, so the technical problem is on your end.
Okay, and what is the technical problem?
Maybe if you turn off the camera for a bit, even though.
So Régine, we're just getting a low network signal. It seems to have stabilized at the moment. So.
Of course. So,
Yes,
okay, so let's
good.
try again. That's good? Okay, perfect. Sorry about that. So as I was saying, so private law in civil law, and essentially private law is this idea regulating relationships between individuals, between citizens, and the relationship that I want to focus on is parent-child relationship. So I was hopeful that I will cover 3 things in my presentation, which is very unlikely. So I've decided to narrow down to 2 things. First, the context led to the modification of the civil code and to the regulation of parent-child relationship, and some feminist challenges that I want to highlight in the context of the substance of the rule modified and amended in the last few years. And when I think about and when I talk about feminist challenges, I want mostly to focus on women's agency and on the biological, or for my purposes, on how parent-child relationships for women are animated by biological essentialisms. So again, I'm focusing on parent-child relationship as they are constructed by law and as they are conceived through law. So in terms of context, Quebec changed the civil code as a result of a decade of different form of advocacy. So starting in 2013 with the decision in Quebec Attorney General NA, the Supreme Court of Canada found that the Civil Code's exclusion of cohabiting couples from protection offered to married couples, so the exclusion was discriminatory, 5 versus 4, but it was justifiable under Section 1 of the Charter. So essentially, the highest court of the country said that the regime for conjugality in Quebec was discriminatory, but that it was a limit that was possible in a free and democratic society. Dr. Alain Roy was the expert for the Attorney General there. Then the Parti québécois mandated Alain Roy in 2013, following that decision, to do a comité consultatif on family law. And this comité consultatif made 26 meetings. It consulted with different experts. There were dissenting opinion, and essentially presented a document to the Liberal government in 2015 proposing ways to reform the entirety, not just conjugality, of family law in 2015. In 2018, Alain Roy, so the same person as the leader of the Comité Consultatif and the expert of the Attorney General NA. So in 2018, Alain Roy, with the Chambre des Notaires, led une commission citoyenne sur le droit de la famille, so which essentially was an 8 days audience in 6 different cities about different people's perception of the law or regulating families in Quebec. 2019, also in 2018, Alain Roy publishes a manifesto signed by former AG of Quebec about the necessity to change, amend, and reform family law in Quebec. 2019, new government, Coalition Avenir Québec, Sonia Lebel, Attorney General, asked for a consultation on conjugality, with, again, the expert being Alain Roy. And in 2020, new Attorney General, Simon-Jolin Barrette, appoints Alain Roy as expert in a process that will lead ultimately to 3 bills, 2 of them being relevant for my purposes this morning. So I hope that from this rather boring context overview, you got a few things. We had significant variation in government, Québécois, Coalition Avenir Québec, and Liberal government. Since 2013, there is some ideological uniformity in the way that everything that has steam from the government has been led by Alain Roy in terms of family law reform. And you hopefully noted that everything I talked about was about adult relationship or conjugality, and nothing was actually about parent-child relationships. Yet, 2 bills came to modify the law of person and filiation. Filiation is civil law's way to refer to the functional equivalent of parentage to engage essentially with parent-child relationship. So those 2 bills, Bill 2, an act respecting family law reform with regard to filiation and amending the civil code in relation to personality rights and civil status, and Bill 12, an act to reform family law with regard to filiation and to protect children born as a result of sexual assault and the victims of that assault, as well as the rights of surrogates and of children. That's a mouthful. And of children born of surrogacy project. So those 2 bills came to change the civil code and the way parent-child relationships. So some emphasis was made, and I will talk about that, so that we now talk about father, mother, and parent in the code. But those 2 bills, initially Bill 2 was supposed to engage much more than it did with filiation, but considering significant problems with the reform that they were putting forward for the law of persons, these modifications did not make it. So essentially, Bill 12 came to implement a lot of the proposition for modification that were made in Bill 2. And Bill 12 came to change the general rules for parent-child relationship, to provide with a regime for surrogacy, and to add a lot of different things, but also some articles of the Civil Code dealing with filiation in the context of a sexual assault. Always in terms of context, I would like to point out that finally, a bill engaging with conjugality was presented and assented in 2024. Starting in 2025, the Civil Code will include a parental union for de facto spouse, which is, just in order to put that in perspective, what we were trying to get, albeit in a more, I think, little icon on this. So that's it in terms of the context. So this bill includes parental union for de facto spouse, include parental union and de facto.
I'm sorry, Régine, you're cutting
spouses
out a little bit.
in succession, which is a rough equivalent of will and estate. Allow. I'm not sure as to what I can do. Can you hear me now?
Yes, we can. I just wonder, is there any possibility for you to connect through your phone? The connection might be stronger.
Through my phone, sure, but
if you can connect your, just using the data from your phone, maybe it might be a stronger connection, but otherwise just keep going. It's okay.
I'm sorry. I feel it's going to take 5 minutes, which is essentially what I have left. So
go ahead, then carry on. Sorry.
I apologize for the connectivity issue. So I'm going to proceed fast then, because I don't want you hearing half of what I say and this being completely boring. So I want to put the emphasis on a few things that were made in Bill 2 and Bill 12 that, in my opinion, raise significant feminist challenges. So I want to show you some of the modifications that were made. One of them is in the Book of Person. And all of this, again, is in the context in which Quebec should have been thinking about reforming family law as a whole, about engaging meaningfully with conjugal relationship, but in which political choices were made to actually look at parent-child relationship. Something that was made that I think is worthy to mention and that we need to engage with, and that there is now an inclusion of Article 34.1 in the Civil Code. So for a child to be considered as conceived but not yet born for the purposes of the law, the mother and the person who is to give birth must be pregnant with the child. It is unsure as to what this is for and why it is there. Essentially, we have been told that it was for succession purposes, but it came and it comes under a section about personality rights and respects of rights of children. Yet the law is clear in Canada in both common law and civil law. There is not such a thing as a child conceived but not yet born when it comes to the child or the fetus as a legal category. And I am worried that this article and its positioning in the Civil Code could lead to unexpected outcome, depending on who is going to have to interpret this article. Something else that I would like to mention is the new Article 113.1, in which the state effectively imposes on the mother to declare their affiliation. This imposition is made only for mother or person giving birth. So essentially, when it comes to civil law, filiation is built so that you declare, and you either declare, and I will talk about that in 1 minute, or you are found to be the mother or person that gave birth because of the delivery. Those are the new rules. They are problematic in and of themselves, if you ask me. But what I want to put the emphasis on 113.1 is that there is now a positive obligation on women or person delivering or giving birth to declare their filiation. Obligation that is not that does not exist, for a second parent or for a father. So I see in that really an essentialism, biological essentialism of women's function and reproduction, which I think should be disconnected from parent-child relationships in a lot of ways. Something that also was made that I think is worthy of attention is that civil law affiliation by blood and affiliation by acknowledgement. So there was some renaming of different aspects of affiliation. We now talk about affiliation by acknowledgement or by blood. So birth, blood, and acknowledgement. Birth include acknowledgement, blood, and parental project. We are not using anymore paternal or maternal affiliation. However, affiliation by blood will be limited to mother or parent, and it will be attached by the fact of giving birth to a child. I would like also to note that the child is always referred to in the masculine form when it comes to the modification, despite Quebec trying very hard to make these rules as gender neutral as possible. So the affiliation by blood is essentially the new maternal affiliation and relies on giving birth, where the affiliation by acknowledgement is essentially the former affiliation, paternal affiliation, and relies on the declaration of birth. So there is an intent element when it comes to affiliation, paternal affiliation, that is absent when it comes to maternal affiliation or affiliation by blood. And it is interesting to me because parent-child relationships are deemed to be vested in the same way, but they have clearly distinctive theoretical foundation, despite the fact that they attach the same duties, obligation, and overall effects. And since I have 42 seconds left, and I don't see people waving at me because my camera is closed, I just want to say that there are other rules that I think are problematic that always refer us to 523 in the context in which there are problems in the context of assisted reproduction. So if conditions for validity of parental project are not met, we will resort back to filiation by birth rule, filiation by acknowledgement, or by blood. But the only filiation that will be established is actually the filiation by blood, meaning maternal filiation, meaning the filiation of the person who's going to give birth. And there is no, as you can see on the screen, especially in FINE from 539, there is no mechanism to locate the second parent that is clear under those rules, given the fact that no bound affiliation can be established with regard to a third party or for the person that was in the parental project. So I apologize for the technical difficulty. I hope that you enjoyed the presentation and that you got some connection with the biological and that you saw that I am quite puzzled by the recent move to change filiation rules in the Civil Code of Quebec. Thank you for your attention.
Merci, Régine. Merci. We're going to continue with our third presenter, who is Sabrina Zeghiche. Sabrina Zeghiche est stagiaire postdoctorale au département de travail social à l'Université du Québec en Outaouais, over there. Ses intérêts de recherche s'articulent autour des enjeux en lien avec la concrétisation d'un projet parental et plus précisément autour du décès, deuil périnatal et de la conception, de sperme. La présentation sera en français, oui. Le titre de la présentation, j'avais le titre en français. Je suis le fruit d'un acte contraire à l'éthique. It sounds better in French. I am the result of something ethical. Merci, Sabrina.
Est-ce qu'on m'entend? On m'entend bien? OK.
Oui.
Donc, as mentioned, my presentation will be in French. My PowerPoint is in English, but please feel free during the discussion to ask your questions in whatever language. Before I start my presentation, I just want to thank the organizers for inviting me. I'm very honored to be here today, especially at Ottawa U, where I did my studies in my PhD studies in sociology. So I feel like I'm back home. And I'm also very honored to be sitting next to Jody, whose work on fertility fraud have been really important for my research. Donc pour commencer, je voudrais juste dire, ah non, c'est ici. Donc, c'est un peu le plan de ma présentation, tout ce qu'il y a de plus classique. Je vais définir le terme d'insémination frauduleuse, qu'on entend par là. Mais avant ça, je voudrais juste dire que les données que je vais vous présenter aujourd'hui sont le fruit d'une recherche qui a été financée par le Conseil de recherche en sciences humaines, qui portait, donc c'était un plus gros projet qui portait sur certaines dérives en contexte de conception de sperme, dont l'insémination frauduleuse faisait partie. Donc, qu'est-ce qu'on entend par insémination frauduleuse? L'insémination frauduleuse, c'est un type spécifique de fraude en matière de fertilité, où le professionnel de santé, souvent le médecin, va fournir de fausses informations sur l'origine du matériel reproductif qui va être utilisé lors de l'insémination. Donc, il va fournir de fausses informations sur l'origine de l'échantillon de sperme qui va être utilisé. Je vous donne un exemple très concret. Donc, une femme va consulter un médecin spécialiste de la fertilité pour concevoir un enfant, seul ou en couple, et le professionnel de santé va l'inséminer intentionnellement avec un échantillon de sperme différent de celui qu'elle a choisi, qu'elle et son couple ont choisi. Dans certains cas, elle va être inséminée avec le sperme d'un donneur alors qu'elle avait choisi le sperme de son conjoint. Dans d'autres cas, elle va être inséminée avec le sperme d'un donneur X alors qu'elle avait choisi un donneur Y. Et dans certains cas, elle va même être inséminée avec le sperme du médecin qui l'insémine. Alors, ce phénomène a été très peu documenté dans la littérature scientifique. Ce que nous savons, pour remettre un petit peu dans le contexte, c'est que la première insémination réalisée dans un établissement médical, qui date de 1884, impliquait justement de fausses informations fournies sur l'origine du matériel reproductif. Donc, la patiente qui a été inséminée, elle l'a été avec l'échantillon de sperme d'un étudiant en médecine, mais sans qu'elle le sache, ni elle, ni son mari, et sans qu'elle n'y consente non plus. La majorité des cas connus aujourd'hui remontent aux années 70 et 80. Il y en a qui remontent un peu plus loin, mais certains cas sont aussi récents que les débuts des années 2010. Aujourd'hui, on estime à plus de 50 le nombre de médecins mis en cause pour de tels actes, et de plus en plus de cas sont révélés au grand jour. Donc, dans ce contexte, on a voulu examiner ce phénomène de plus près en réalisant une étude qualitative sur les personnes conçues dans un tel contexte, dans un contexte d'insémination frauduleuse. Et dans le cadre de ma présentation, je vais vous parler plus précisément de l'impact de ce phénomène sur l'identité perçue de ces personnes. Donc, entre l'automne 2021 et l'hiver 2022, on a mené des entretiens semi-structurés avec des personnes adultes qui avaient découvert qu'elles avaient été conçues dans un contexte d'insémination frauduleuse. Le recrutement a continué dans un deuxième temps. Donc, récemment, on a rencontré plus de personnes, mais dans le cadre de ma présentation, je vais vous présenter les résultats des données qui ont été analysées jusqu'ici. Donc, au total, on a rencontré 17 personnes, 4 personnes plus récemment qui se sont ajoutées à cet échantillon, mais pour l'instant, c'est les données des 17 personnes dont je vais vous parler aujourd'hui. 13 femmes, 3 hommes et une personne qui s'identifiait comme étant non-binaire. 9 provenaient des États-Unis, 6 du Canada, une personne du Royaume-Uni et une personne de l'Équateur. Et notre échantillon recouvrait différents types de substitution d'échantillons. La majorité concernait la substitution du sperme du donneur ou du père par celui du médecin. Mais dans 2 cas, on avait le sperme du donneur qui était substitué par le sperme d'un autre donneur. Et dans un cas, c'était le sperme du père qui était substitué par le sperme d'un donneur. Alors, 2 thèmes principaux se sont dégagés de l'analyse des données. Le premier thème, c'est un réalignement identitaire. Et le deuxième, c'est le sentiment d'une identité souillée. Ici, je veux juste clarifier que ce qui est propre à l'insémination frauduleuse, c'est vraiment la conjonction de ces 2 thèmes. Donc, autant le premier peut être noté ou observé dans d'autres situations, mais la combinaison des 2 est vraiment ce qui est spécifique à l'insémination frauduleuse. Donc, pour chaque thème, on a 3 sous-thèmes qui se sont dégagés, et dans les diapos qui suivent, je vais détailler chaque thème et chaque sous-thème séparément.
Donc, le premier thème, l'insémination frauduleuse implique que la moitié du patrimoine génétique des personnes concernées est différent de ce qu'elles imaginaient jusque-là. Ce qui les contraint à ce que j'appelle un réalignement identitaire, c'est-à-dire réconcilier l'identité qu'elles pensaient avoir avec les nouvelles informations qu'elles découvrent quand elles découvrent la fraude. On ne doit pas avoir une vision réductrice de l'identité qui va la confondre avec la génétique, parce que bon, on sait que l'identité, c'est beaucoup plus complexe que ça. Il y a beaucoup d'éléments qui viennent entrer dans sa constitution, notamment des éléments non génétiques. L'identité n'est pas statique, elle est mouvante, bien sûr, mais on ne peut pas ignorer le fait que l'insémination frauduleuse met en lumière le fait que certains éléments sur lesquels reposait l'identité des personnes jusque-là doivent être réinterprétés à la lumière des nouvelles informations que la fraude révèle. Donc, qu'est-ce que ça veut dire découvrir qu'on a été conçu dans un contexte d'insémination frauduleuse? Ça veut dire aussi découvrir du même coup que certains éléments sur lesquels reposait jusque-là notre identité sont faux et se sentir dépouillé d'une partie de soi. C'est ce que les personnes qu'on a rencontrées nous ont dit. Pour de nombreuses personnes, la perte du lien génétique avec leur père, avec leurs frères et sœurs et leur famille paternelle est vécue comme un deuil. Shannon dit « Avant la fraude, j'avais 2 frères et sœurs génétiques, des full siblings, comme elle dit en anglais, et là, je n'en ai plus aucun. » La découverte de la fraude peut amener certains à repenser les dimensions aussi culturelles ou religieuses qu'elles pensaient avoir héritées de leur père. Et si certaines personnes ont décidé de quand même conserver cet héritage-là, même après avoir découvert la fraude, d'autres vont dire qu'elles ont plus de mal à continuer à s'en revendiquer une fois qu'elles ont découvert la fraude. L'insémination frauduleuse va entraîner aussi une période de confusion marquée par des questionnements identitaires. Qui suis-je vraiment? De qui je tiens tel ou tel trait physique? Ai-je des demi-frères et sœurs? Qui est mon géniteur? Et pour plusieurs personnes, elles ont déclaré que la fraude les privait du droit fondamental de connaître leurs origines, surtout quand le donneur n'est pas connu, en sachant que les médecins souvent détruisaient les dossiers. Donc parfois, il n'y a aucune façon de retracer le géniteur. Et ça rendait leur construction identitaire, du coup, plus ardue. Et ça les mettait dans une situation un peu de ce qu'elles appellent un peu de flottement identitaire qui peut durer des mois et pour certaines personnes des années ou ne jamais retrouver vraiment leur identité. Les personnes concernées disent alors ne plus très bien savoir qui elles sont. Certaines rapportent même avoir de la difficulté à se reconnaître dans le miroir. Émilie, par exemple, confie avoir ressenti une certaine dissociation avec son propre visage, son propre corps, une fois qu'elle a découvert qu'elle n'était pas la fille biologique de son père. Ce n'est pas le cas forcément pour toutes les personnes en fonction de l'importance qu'elles accordent à l'aspect génétique de leur identité. Et parmi les personnes qui ont découvert leur nouveau patrimoine génétique, certaines ont pu se recréer une nouvelle identité avec de nouveaux liens génétiques, de nouvelles origines ethniques ou religieuses. Qui m'exprime bien ce processus un peu ardu. Elle dit « J'ai dû vraiment fournir beaucoup d'efforts pour déconstruire mon ancienne identité afin de me reconstruire une nouvelle identité. » Je vous donne un exemple d'une autre personne, Steve, qui a été élevé dans la religion catholique et dont le père était britannique. Il a expliqué comment ça a généré un nouveau processus identitaire quand il a découvert qu'il avait été conçu avec le sperme du médecin qui était, lui, juif ashkénaze. Il a déclaré qu'il se considérait quand même toujours comme Canadien de première génération et comme Britannique en raison de sa filiation avec son père, mais qu'il était maintenant en partie juif, donc il compose avec ses différentes identités. L'insémination frauduleuse peut aussi révéler de nouveaux liens génétiques, notamment avec les demi-frères et sœurs. Et lorsque ces relations donnent lieu à de véritables liens, elles peuvent modifier aussi le paysage familial des personnes concernées et la place qu'elles y occupent. Donc, par exemple, Émilie toujours ne se considère plus comme enfant unique puisque maintenant, elle s'est trouvée une fratrie. Je vais vous lire le verbatim d'Anthony, juste un petit peu de contexte avant de vous mettre son verbatim. Il a découvert qu'il n'avait pas de lien génétique avec son père quand son père était sur son lit de mort. Donc, Anthony, à ce moment-là, avait vers la fin quarantaine. Il n'avait jamais soupçonné que ses parents étaient allés en clinique de fertilité. Et il a été bouleversé par cette information-là parce qu'il était très attaché à son héritage scandinave paternel. Donc là, la citation, c'est son ressenti avant qu'il découvre qu'il a été conçu avec le sperme du médecin. Il dit ceci: « Those little building blocks in life that built who you are weren't who I thought. I had my strong Norwegian heritage. I still have, but I don't. So what am I? I'm stuck in this limbo. » Donc le deuxième thème, qui est une identité souillée. Donc, comme je vous ai dit tout à l'heure, c'est vraiment la combinaison de ces deux thèmes qui font la spécificité de l'insémination frauduleuse, parce que le réalignement identitaire, on peut le trouver dans d'autres contextes, dans des contextes de ce qu'on appelle une expérience de filiation mal attribuée. Donc, qu'est-ce qu'on entend par filiation mal attribuée? Ce sont les situations où une personne grandit en pensant qu'une certaine personne est son parent biologique, pour finalement se rendre compte que ce n'est pas le cas. Donc, dans ce cas-là, il y a un réalignement identitaire, mais ce qui est propre à l'insémination frauduleuse, c'est que la tromperie concerne à la fois les parents et les enfants, et qu'en plus, elle implique que la conception même des personnes concernées repose sur un geste qui est éthiquement répréhensible, d'où ce sentiment d'une identité souillée. Donc, plusieurs personnes conçues dans un contexte d'insémination frauduleuse ont dit avoir éprouvé un profond sentiment de honte et de culpabilité parce qu'elles ont l'impression d'incarner ce qu'elles perçoivent comme une atteinte à l'agentivité de leurs parents et à l'intimité de leur mère. Alors, pourquoi une atteinte à l'agentivité de leurs parents? Parce que le médecin, en échangeant intentionnellement les échantillons de sperme, sans le consentement de leurs parents, a délibérément ignoré le projet parental de leurs parents et donc délibérément ignoré aussi leur volonté de créer la famille dont ils rêvaient. Et Amanda dit « J'avais l'impression de ne pas être l'enfant pour lequel ma mère avait payé ». Et pourquoi une atteinte à l'intimité de leur mère? Parce que le sperme d'un étranger a été inséré dans leur corps, dans une partie intime de leur corps, sans leur consentement. Et certaines personnes ont vécu cet acte-là comme une agression sexuelle. Et donc, pour les personnes conçues dans ce contexte-là, il y a vraiment un sentiment d'être souillées parce qu'elles se sentent comme étant l'incarnation de ce geste. Les personnes conçues avec le sperme du médecin ont fait part de leur profond malaise d'être génétiquement liées à l'auteur de la fraude, une personne pour qui elles ressentent une profonde aversion. Émilie, par exemple, explique que lorsqu'elle a appris qu'elle n'était pas biologiquement reliée à son père, elle avait encore l'espoir que son géniteur soit quelqu'un, une personne honnête. Et quand elle a découvert que c'était le médecin, cet espoir s'est anéanti. Et donc, certaines personnes vont commencer à interroger leur propre sens moral du fait justement de ce lien génétique avec le médecin. Nicolas, par exemple, s'est posé la question, est-ce qu'il y a en moi quelque chose de génétique qui me prédispose à agir comme le médecin? Et donc, plusieurs personnes se sont mises à scruter leurs moindres faits et gestes à l'affût de la moindre faille morale. Et certaines personnes vont arriver à se poser la question de la légitimité de leur propre existence. L'idée que leur naissance repose sur un acte contraire à l'éthique va les amener à penser qu'ils n'auraient jamais dû venir au monde et que leur existence n'est en fait qu'une erreur. Et donc, c'est assez douloureux pour ces personnes-là. Brandon explique, par exemple, qu'il se sent comme le produit d'un acte qui n'aurait jamais dû se produire. Olivia explique qu'elle a cessé même de fêter son anniversaire parce qu'il lui rappelle ce que le médecin a fait. Une autre citation pour illustrer ça, Alison, elle a découvert qu'elle était conçue à l'âge de 10 ans et ce n'est que vers la mi-trentaine qu'elle a pu reconstruire son arbre généalogique. Et c'est là où elle s'est rendue compte qu'elle avait été conçue avec le sperme du médecin. Et en réalisant qu'il y avait de plus en plus de personnes qui étaient dans sa situation, elle a ressenti vraiment un sentiment de dégoût et elle dit ceci. I share half of my DNA with some sick, c'est pas vraiment person qu'elle a dit, mais je vous laisse imaginer le juron qu'elle a utilisé, who repeatedly violated women. How can I be a good person when I share his DNA? I think being donor conceived is hard enough, But with fertility fraud, you feel like you're a product of rape. Et j'en arrive à ma conclusion. Donc, cette étude souligne le fait que l'identité personnelle, génétique et familiale peut être profondément affectée par l'insémination frauduleuse. Et il est important que les personnes concernées soient reconnues par les décideurs, par la société dans son ensemble. Les mesures préventives et punitives sont encore insuffisantes et on entend encore beaucoup de commentaires qui tendent à minimiser leur vécu. Et donc, c'est important aussi que ce phénomène reçoive l'attention qu'il mérite du milieu médical, juridique ou sociétal. Merci.
Merci, Sabrina. Merci. We're going to move to our final presenter, Jody Madeira. Dr. Madeira is a distinguished faculty member at Indiana Law, where she specializes in fertility, fraud, bioethics, and intersection of law and medicine, with a specific focus on reproductive endocrinology. Her expertise in reproductive rights and health has been featured in a number of media outlets, including a Netflix documentary called Our Father and the ABC Investigative News Program 2020. Madeira's work, scholarly work, extends to empirical research also on the emotional and legal aspects of fertility and reproduction. Her presentation today is a new title called Seeds of Doubt. I have an older title. Thank you, Dr. Madeira.
All right. Yes, I suppose the microphone would be helpful. There we go. All right. This research actually has its roots in what we just heard about, fertility fraud cases involving physicians like Norman Barwin here close by, who use their own sperm to inseminate female patients without their consent, largely in the 1970s and 1980s. Shockingly, the most recent case we have of this is 2009 from a fertility physician named Christopher Herndon at the University of Washington. It was a procedure performed at the University of California, San Francisco, which raises the questions of, these doctors performing this activity in multiple states. Then we also have a clinic technicians. The most recent case we have of technician fraud is 2023. The child was I think is just about to be born or was just born. So it is still ongoing. And so it's still a relevant regulatory project in its own right. So I've embarked on a huge advocacy project in the United States through my involvement in the Dr. Klein case in Indianapolis, which has resulted in 100 doctor-deceived children. We've passed state laws in 13 states since 2019. We're actively working on 3 more. We also have a federal bill, HR 451, which would criminalize this conduct on a federal level. We have 55 Republican and Democratic co-sponsors. It's a bipartisan issue. However, it is a mess right now. And so we've pulled the bill back and we're going to see what the priorities of the new administration are, because we also don't want to be a vehicle for embryo personhood legislation. So, but now, hold our beer, we have fertility fraud 2.0, which is serial sperm donation. So a growing number of men across the world are styling themselves as professional sperm donors. They're referred to as serial sperm donors or sperm kings or super donors or sperm bros. And they're largely critics of the mainstream fertility industry. They will travel to donate, will travel for sperm. They don't charge for sperm. They just ask people to contribute to their travel costs. This became especially prevalent after COVID caused a shortage in sperm donations to banks. Men stopped going in so rapidly to donate, even as people's flexibility increased and the demand to build families rose. They use social media very prominently. The typical client cannot afford traditional assisted reproductive technology services. They can't access it, or they simply want different, perhaps less medicalized policies. Sperm bros donate through natural insemination, which is sex. Others donate through cups. Some donate through a combination of both. These people also encourage an anti-industry orientation. Several donors and hopeful recipients basically connect on the basis of avoiding and pride in avoiding the traditional industry. They feel like they're getting a bargain. They feel like they're escaping controlling industry or institutions, etc. So there's some pride in it, at least for the donors. Normally, sperm is quarantined by a bank 6 months after donation. Men have to return each time a batch is released to be blood tested. Sperm banks also have limits of 25 to 30 families. But sperm donors, even though they sign agreements to donate only at that bank, they can also basically choose with impunity to donate at other banks or on Facebook or both. A vial of sperm can cost as much as $1,100 or more. Also, people are just turned off by the fact that donors are identified by numbers, and that they're donors, even if they're open and not anonymous, which is a strange relic we have in the United States. These people's identities can't be legally revealed until the child turns 18, even though sibling pods or recipients frequently identify donors beforehand. Donors often use sperm shipping tools like Natal Donor or storage firms like DaddyKit, and they use 23andMe to assure that there are no mutations, although we have at least one serial donor that has adjusted his 23andMe report to get rid of a disorder called familial dysautonomia. So we have, I'll just talk about that later on. Also, as I mentioned yesterday, it's interesting that there is no sexual philias or areas of psychological sexual deviance for people who want as many children as possible with no involvement in those lives. It kind of is like a Genghis Khan syndrome, but it seems to be something to which all the serial sperm donors are very attracted. They want to have lots of children, and they don't really want to visit their children. Only one sperm donor, Adam Hooper, really undertakes efforts to visit and remain a part of the lives of the children he has conceived through donation. Interestingly, we also have more visible examples of perhaps serial sperm donor wannabes, like Elon Musk, Pavel Durov, and Jeffrey Epstein. And so, I'm interested in my research as I talk to people involved in underground donation and serial donation, how they perceive these billionaires who are, paying for IVF for women who use their sperm or offering their sperm, and perhaps housing the mothers of their children on compounds. Strangely, how do they perceive those in relation to sort of like the average Joe, if there is an average Joe donor, who donates through Facebook? So they recruit there are about 10 donors that I can think of throughout the world who are especially well known, and they sort of have a monopoly on this activity. They maintain sites like Sperm Donation USA. This is from a while ago, the front page of the Facebook site. And you'll notice that these sites have tens of thousands of members. These guys also get a lot of coverage. Some donors like Adam Hooper spread awareness of practices that he considers unethical in the industry, as well as spreading his seed. He talks to the media. He tries to recruit new donors. Hooper's interesting because he is unusually vocal. He shows people that there's a different way of doing things. He wants the process to be less anonymous, less expensive, more relational, less clinical, and he wants donors to vet parents of their children to ensure that they will, quote unquote, be raised well, whatever that means. Interestingly enough, Hooper, who's an administrator of one of these very large Facebook groups, also pretends to heavily vet members of these groups. He says that he just has a gut instinct to determine whether these people are perverts, and that his system is legitimized because they, quote unquote, haven't had any rapes, sexually transmitted diseases, or assaults. And so I beg to differ with that. The people I've talked to have felt violated in a number of ways. So some examples, this is primarily our first example. Jonathan Maurer is perhaps the most visible serial donor right now, and you can still see his videos on YouTube. He puts them up on a pretty regular basis. He's a Dutch musician who fancies himself the quote unquote Viking donor. He lives in The Hague, and he donated through Cryos, which is the world's largest sperm bank, but he also donated through other banks throughout Europe, the United States, and other countries, and also donated through groups of parents that he met up with on Facebook. He has, I would say he has 1,200 children. It might be as high as 1,300 or 1,400. Basically, where it's very hard to track because most of the women are in contact with each other. This case has received a lot of publicity. And so people who suspect that he might have been the donor that they chose often get in contact and through genetic testing then confirm that he is in fact the donor. Women who conceived with the sperm, with Maurer's sperm, primarily connected on Facebook. The groups that I have worked with from Maurer as victims are ones that chose the sperm through Cryos. So they tried to go through the industry, and they found out that in fact they were in the same position as someone who they thought would have made an unwise choice by going through an underground sperm donation system. So basically, he has children in a number of countries that are listed there. The interesting thing about him was that he was investigated in April of 2023 by the Dutch Ministry of Health, Welfare, and Sport because he had fathered so many children in the Netherlands. And in the Netherlands, they believe, as I wish they did in the States, that children have a right to certain identity goods, including the right to grow up without fear that you're going to marry your half-sibling. And so on those grounds and in others, they ordered him in an unprecedented opinion to notify all clinics, to have all samples destroyed that were not yet sold, and to stop donating or else face a fine of 100,000 euros. He has actually not complied with this. He has stopped donating most places in the world, but he still is donating in Kenya. And I can, if you want to know that about that in questions, I will discuss what's going on in Kenya right now. And I think there are two of us actually who can answer that here. So some others, Simon Watson in the UK has over 800 children. He will just provide sperm free. He'll just meet people like in rest stops off different highways and exchange. I talked about Adam Hooper already. Kyle Gordy is primarily on our radar. He now has 72 children. He administers the website Sperm Donation USA. He is kind of an attention whore. So he was on 90 Day Fiance in the United States. And he is also one of the only donors who we've been able to stop going from country to country. So he was caught actually in Fiji on his way to New Zealand and basically detained for not being honest about why he was donating, which is one potential way to catch these folks. That's a question I'll raise at the end. So why would anyone do this or use these services? Well, again, fertility clinics are very expensive. And clinic mix-ups are frequently in the news. So even if you go through a clinic or a bank, it's not exactly certain you'll get something that resembles ethical clinical practice. Also, there's a number of problems with this: accidental incest, high numbers of children per donor, the potential for donors to mislead recipients, exploitation, sexual exploitation. We have people who match up with a donor and then basically meet up for natural insemination or sex and are basically forced to perform non-procreative sexual activities and bring rape charges. And the police are like, you had sex with somebody to conceive a child? No. And they refuse to bring the rape charge. We also have donors that misrepresent genetic conditions. Kyle Gordy is one such. And then these donors who maintain the Facebook groups bring women who are pregnant with their children into smaller groups, basically like online Facebook harems. And if these women begin to criticize the donors, if they feel that the donors are not being forthcoming about genetic conditions or about numbers of children, they threaten to remove the women from these Facebook groups. And so they basically force silence upon their recipients. So known patterns of victimization. Again, the knowledge that your half-sibling suddenly has several, that your child has suddenly several half-siblings across multiple countries. We also have a pattern of victimization where hopeful donors pay $250 or more to these sperm bros who maintain the groups to recommend them to women who think that they are more vetted or more tested or approved than other donors on the website. I mentioned the Facebook harems before. And it's very hard to push criminal charges under existing law. It's hard to regulate. This looks like a one-night stand. There's potential fraud charges, but again, how are you going to prove that someone actually misrepresented their genetic conditions, because you often don't record conversations with these people? Potential charges for rape by deception, but very few states in the United States have these types of laws. We have some situations where donors who are adult have swiped right on each other, dating apps like Tinder, and then found out they're related. We have women in the Netherlands that sent their children to the same daycare that realized their children looked a lot alike and realized their children were both Jonathan Myers. And then, so the question is how to regulate. Can we combat this on social media? Is this a legal issue? Can you block travel, but then you run into constitutional questions? There's a potential for a UN petition that doesn't really have much weight in the United States, but it might raise the profile of this issue across other countries. I want to take some time briefly to talk about this new front, which we've discovered in the past month and a half. So this is actually very disturbing, and I apologize if it's triggering to anyone. These are individuals who are convicted of child sex offenses that would prohibit them in states from living with the child they were parenting. They attempt to have a child, often using donor sperm through a clinic or surrogacy agency to that they will sexually abuse or allow others to abuse. So this is actually sex trafficking. We have one case involving 2 women from Florida that occurred in the 1980s. We're not saying that someone with a criminal history should not be a parent, but we're acknowledging that some people have abused children so severely that their ability to parent is limited by law. But fertility clinics and surrogacy agencies don't do background checks or criminal history checks. They're supposed to. They're more likely to do so if they follow a so-called adoption model for surrogacy, where you get a home study and a criminal background check, but that's not always required. Surrogacy agencies are especially problematic. They aren't bound by medical standards that influence clinics. Nurses, and I have at least one interview with a nurse that I've done where this happened. They may see unethical conduct, but they cannot testify about it due to non-disclosure agreements. Clinics and agencies also have no connection or oversight from states or law enforcement. So the conduct is discovered through other means, like reports to child services after a child is born and is being abused. And I put this in fertility fraud. We are trying to amend the fertility fraud laws in states where we have passed them to include this activity. But it also kind of resembles more like negligence. Here, the intended parent deceives the clinic or agency, not about the source of sperm, but that it's about a characteristic that's critical to their ability to parent. And so I have to wrap up here because I'm out of time. So my instinct is to get a law review article out there, like I did for fertility fraud, that analyzes this issue as soon as possible. But how do I really write about this? Are these the same topics? Should they be covered in the same paper? So I'd really love advice on how to handle this problem as well.
Wonderful. Thank you, Jody. And thanks to all the panelists. We have a fair bit of time for, probably about half an hour for questions. So do we need to bring the mic out, or is this, oh, there's a mic there. Okay. So whoever would like to sort of get us started as far as questions. Régine, est-ce que vous êtes là?
Oui.
Okay, parfait. I just want to make sure Régine's online. Please.
Yeah. Okay. Hi, I was wondering if you could say more about what's happening in Kenya, because so I watched the Netflix documentary and it sort of left off on this really like white supremacist note, but like didn't really say much. And I assume that was because the lawyers probably said you can't say things that haven't been proven yet. But there was this like overtone of like whitening the world. And I'm wondering if that's what's happening in Kenya, and if you can say more about that.
Yes, what's happening in Kenya is basically, colonialization through sperm donation. And so to the point where serial sperm donors are often recruited by Kenyan banks because they have a reputation for producing a lot of viable sperm fast. And Kenyan banks, of course, Kenya does not really regulate the assisted reproductive technology industry. And they have clients who want basically sperm that will create children with a lighter skin for social purposes of social capital. And so the Kenyan banks just feel like they are giving citizens what they want. The donors, on the other hand, 2 problems. First of all, Kenya has a very high rate of HIV positive residents. And so if the donors go over and donate naturally, how are they protecting themselves? How are they protecting recipients, right? And in fact, if they contract HIV, how are we to know about it while they continue to donate, because Kenyan banks don't test sperm this with the same regularity that other countries, even the United States, does. But they actually might be vectors of HIV throughout the country. Second of all, they have not only pushed videos showing that they're whitewashing Kenya, and that's an exact quote from Kyle Gordy, who's over there, but they also have promised people who accept their sperm that their children will become U.S. citizens. That is a false claim. There's no way that you can both be a donor and confer U.S. citizenship on these children. And so, but the recipients don't know that. And so there's going to be a whole class of recipients that come of age and, try to get citizenship. And so then where are these serial donors going to be when that happens? So that's also very unfortunate. Do you have anything to add? It's a mess.
Thank you. Next question, please.
Thank you very much. Super, super interesting panel and super interesting topics. I'm really happy to be here to ask this question and maybe like thoughts from anyone. What I find really fascinating and challenging about the issues of mass sperm donation is because it, in terms of how do you address it, how do you regulate it, I find it like conflicts with my broader strong positions on reproductive rights as a human right. So how do you address this issue, which I think is a very real issue, and I think also like the rights of donor conceived children within the framework of reproductive rights, and without also not undermining those reproductive rights that we are very much still fighting for. Yeah, I'm hoping you have some thoughts.
So when it comes to regulating, we've had some concern. So I think the experiences that we've had passing these state laws sort of bear out the thrust of the question. There are actually two groups that are trying to pass laws in the United States. One group has passed 0 laws because their laws would actually regulate the entire reproductive industry. They want to pass record keeping laws. They want to regulate donors, and nobody's ready for that, according to state legislators. So if we had tried to push such measures in our bills, we would not pass those bills. So when there are LGBTQ groups that look at these laws, they also they confuse, the victims with whom I pass the laws with this other group that's called Right to Know, and they purport to be against all laws without knowing that there is one group that does push narrower laws. So I think one way in which you can regulate this conduct without infringing upon reproductive rights is just have very narrow bills, right? That basically protect people from fraud, because no one has a right to be a victim from fraud, and actually protecting people from fraud allows them to facilitate rights, but you also don't want to limit the numbers of donors, and you don't want to discourage the industry from innovating, and if they think that these laws are too broad and to prohibit them, perhaps they would just shut down certain services, as we saw in Alabama when the LePage decision came down with embryo personhood. They're very finicky about regulation, and it's either hands off or a systematic overhaul is necessary. But this regulation can be hands off, except for allowing civil suits and criminal charges for these healthcare providers that do this that perform these activities. I don't know of how really to regulate the serial donors. The serial donors are much harder because people have constitutional rights to travel. And also, I'm not against the underground donation system, but there should be some recourse for donors who materially deceive people for, genetic health history, that kind of thing. But if you try to regulate for what constitutes a deception about a material condition, then the next thing you know, you're punishing someone for disclosing the wrong eye color or something like that, and going into eugenics. So so I think perhaps the best way to regulate might be public education and extra legal forms of, help.
Yeah, I just want to add something that in terms of like my research group had an event last week where we were talking to some people who have previously donated sperm, and somebody learned that it was discussing their experiences having provided sperm to a clinic every couple of weeks, once a week, something like that, and thinking that it was being used for clinical research, and then it turns out that he's 30 plus related children. So I think enhanced regulation of the industry is really critical here. And many of the serial donors that we've heard about in the various very public cases are people who both engage in what is in French called artisanal sperm donation, the sort of underground sperm donation, and then, but also participate in clinics. And something that I've been thinking about a great deal is how the clinics all use different donor numbers. They all have their own. It would be easy enough to coordinate a system across the world where there are unique donor numbers, so we could look at the same person across different clinics. There's also capacity for voluntary registries where intended parents, people who are using sperm donors, could have their own registries for this. This already exists for donor conceived children, but I don't think there's an awareness of potentially working on that for, again, I keep calling them artisanal sperm donation, but I've been working on this in French. So I think that there are strategies that we can engage with that don't step across the line of potential reproductive rights, while also holding the industry a little bit to the fire on this.
Yeah, I'm glad you mentioned the registry. Colorado is the only US state that has a registry. It's coming online in 2025. But there's such massive distrust among many groups in the US that the registry could also be used to surveil certain people who are having kids, like LGBTQ individuals, that there's massive opposition to a registry. But without a registry, you can't enforce, fraud. I should also note that we've had cases of embryo fraud as well, where embryos that were not free for donation have been sent to couples. So it's not just sperm. There's also embryo swapping as well.
Sabrina or Régine, did you have anything you wanted to add?
I'm good, thank you.
Okay. We have another question.
Yeah, so this is related to the last question, and I appreciate the responses that you all just gave. But I mean, Jody, I think and you said this in your answer, but I think figuring out exactly what you mean by fraud and being very precise is so important. So your slide was fraud, fertility fraud 2.0, serial sperm donors, and I can hear the audience, responses to some of the more shocking things you say. But I think if we rely on sort of emotional reactions to what we think of as sort of abnormal, and you are, in your question yesterday, and you said it again today, kind of trying to potentially, define therapeutically as abnormal people who want to provide sperm to a lot of people, I think that is a real quick slippery slope to people saying, well, there's other forms of reproduction that I don't agree with, that I would prefer to regulate and not have out in the world, including, trans kids preserving their gametes before they go through puberty, or gay or lesbian people engaging in all kinds of different social relationships in order to have children in various ways. So I think we have to be so careful, and we have so much historical and sociological evidence of the very quick step from calls for regulation to then become massively discriminatory. And I will just offer the example of France here. So when France created their national sperm bank in the 1980s, it is state-run. They know exactly how many donors they've had. They know exactly how many children have been born. They know exactly how many of those children have had what kinds of health problems. But they wrote discrimination into those regulations in the form of you had to be a married heterosexual couple to access that sperm. And it took decades to challenge that. And so I get, so I didn't talk about this yesterday, but I wrote an earlier book on the markets for egg donors and sperm donors. To this day, I talk to reporters all the time, and the first question is, how do we regulate this? And I'm always like, whoa. I think we need a lot more information about how many people are involved in this, but I think the kind of easy step towards what everybody's thinking towards regulation really requires us all to be extraordinarily cautious. So I think your presentation includes a lot of different kinds of criminal activity. There are laws against sexual assault and rape. There are laws against, various forms of deception. So do we really need an additional law specifically about this that defines as problematic people's reproductive decisions?
Yes, I'll just say the question of regulation comes because different entities around the world are trying to figure out how to regulate. And so, like I said, I'm actually in favor of the underground market. I think it is a form of reproductive freedom, and I don't think that it's healthy or productive to regulate that necessarily. And I agree completely that a lot of criminal laws, such as sex assault laws, sexual criminal laws, sexual deception, or like I would say, just common law fraud could take care of a lot of these issues. However, I'm alarmed because people are trying to regulate it without really knowing what's going on. So Victoria, Australia is trying to regulate. They're keeping their process entirely secret. I went over there, spent 3 weeks over in Australia, New Zealand to try to conduct interviews and see if I could sniff around. I can think of 5 opportunities where I was rebuffed by different government workers to have conversations that would educate them about serial sperm donors, to connect them with people who use underground sperm donation. And so whatever regulation is put in place has to be very much informed and very narrow. And I think that, like I said, regulation is not the way to go about it. But even when you look at the insemination fraud, it has to be incredibly narrow, because we just want to get in, basically capture these doctors or clinic workers that are deceiving patients who did not consent. And it's so easy to capture people, in those nets, even for those types of laws addressing like the more medical insemination fraud. Yeah.
I think we have.
Stand right up. Well, wanted to give some space. I have two questions. I have one for Régine and one for Jody. For Régine, you had noted, Alain Roy was deeply involved in kind of all the different steps of the family law reform. I'm wondering if you can speak a little bit more about the kind of the implications of this from your perspective, his influence on the law, why do we think that this is the case? What were the particular influences or effects of this? What was his particular vision? That might be, I think, really interesting to hear a little bit more about. And then my other question was going back to one of your kind of last slides when you were talking about kind of the deeply problematic, really troubling sex trafficking situation. And you noted how this might be captured in some instances where we have more of an adoption model and we have home study. And I'm just wondering, I was thinking about, okay, like I've thought about this a little bit in relation to my work. To what extent is an adoption model, helpful in this kind of context? I have concerns about having kind of more regulation or oversight over who can be a parent. So I'm wondering if you could speak a little bit more about that.
Maybe start with Régine.
Thank you, Dr. Carsley. So Stephanie, say thank you for your question. So Alain Roy, so I think that first I want to say that without Alain Roy, I don't think would have had any reform. So I think that he does play a crucial role in us engaging with how to reform family law. And I think that he was tasked with something very complicated because initially the problem was with the conjugal regime. And the conjugal regime was not really dealt with until very recently because of all sorts of political reasons. I think that it is much more difficult to regulate conjugality in Quebec than it is to regulate parent-child relationship, especially if we are animated by ideals that are very commendable, such as like the best interest of the child and stuff like that. So I'm grateful for all his advocacy and all his involvement, but I do believe that even if I do believe that in a different political context, in which in the public hearings, for example, and in which the Assemblée nationale would have been more open to all the criticisms that were provided by different scholars, by different stakeholders, by different people with lived experience, I think that we would have had a better results. So I think that it is problematic to have someone that is so heavily implied if there are no mechanism in place for meaningful consultation and implementation of change on the bills that are presented to the Assemblée nationale. But that is my very own perspective on the matter. And of course, other scholars were involved. So Dominique Goubeau was on the Comité Consultatif. Louise Langevin participated in all, if not all, of the Commission des Institutions. So other voices were there, but not in the same, they were not provided with the same gravitas in terms of like who holds the power and who is this, not pushing, but who is promoting a specific agenda. And I would have hoped for a more nuanced engagement from different people with the broad teams. But it's not Alain's fault necessarily. So, and I hope that I don't sound that way. I think that the way we reformed family laws, the way we decided to start with parent-child relationship without engaging much, but for the Comité Consultatif, led to all sorts of the pretense that we were reforming family law when as a whole, when really what we did is just what we have done for decades now. So deal with a discrete issue rather than looking holistically and globally as how to better regulate relationships but in the context of family. So that will be my very long answer to a very complicated question. I hope that it answers some of your concerns or questions, Stephanie.
Thank you, Régine. I think that that second question was directed to you, Jody.
The question of who should be a parent, actually, that's a great question. And that goes back to Renee's question about sexual deviance and the impact upon perceptions, subjective perceptions of what is deviant upon our decision about who should parent or the opportunities for parenting that somebody should have. I take the position that we should not intervene legally or regulatory in a regulatory fashion unless there's a potential of harm, severe harm for a donor-conceived child. And so the problem of mass amounts of donor offspring is harmful at some point because of consanguinity. And so I can't think of any other condition on which I wouldn't intervene. And perhaps the only donor in which I would intervene thus far is Jonathan Maurer, because at the point where he has 1,200 kids in such small pockets where, these kids are going to the same daycare and things like that. We have cases of consanguinity in the United States from fertility fraud. My friend and a fellow victim, Victoria Hill, discovered that her half-brother was actually the boyfriend she had dated for 3 years in high school. And she came out and did a story on CNN that aligned with an attempt to push our federal bill in January of this year. So if you're interested in her story, you can go online and see it. As far as the adoption model, I think I prefer as hands-off a model as possible for similar reasons. We don't have the right to exclude someone from being a parent unless, and again, this is my personal opinion, they've been convicted of such severe criminal sexual abuse for a child that abuse would prohibit them already from being a parent under state law. And my understanding of the adoption model is that most times it's employed just to educate parents and to cross off, check marks under state law that already exists for adoptions. That's just a model that's been laid on top of surrogacy. I actually favor as much privacy for intended parents as possible, so long as they're not making decisions that would harm the donor-conceived child who's born as a result.
Thank you. Thank you, Jody. I think we have one more question, and maybe that'll take us to lunch.
Hi, my name's Maureen McTeer. And my point, I suppose, is that in all of our discussions, I believe we have to have only one major idea in mind, and that is that we are involved in projects to create another human being, to create a new child, a new life. And I think that's important because one of the principles that Parliament laid out, in fact, the #1 principle reads, the health and well-being of children born through the application of assisted human reproductive technologies must be given priority in all decisions respecting their use. And with respect, the system in Canada is so fundamentally different from the United States that while in terms of regulatory and legislation and systems, really, fraudsters get to be president of the United States, but not necessarily, hopefully, in Canada. But we've reached a point now where regulation, there has to be some mechanism designed that applies in our context in Canada, which we are looking to do, many of us who are advocating for these changes, that deal with some of the questions, all of the questions really, that have been raised here yesterday and today. And the importance of that with respect to the interests of the child to be created, I think have to always temper how we proceed. These are not, Canada has, for instance, under the Uniform Law Commission already in each province and territory, looked at the whole question of the relationship, who is a parent, not who can parent, which to me is a sideline issue, but who is a parent. And therefore, under our laws, a whole new set of obligations accrue to that relationship. In 1989, when the Royal Commission was having public hearings across Canada, in the province of Prince Edward Island, in Charlottetown, a doctor presented to us and said how happy he was that he was able to have 500 children created from one sperm donor. our question in a province the size of Prince Edward Island was, what kind of a freak show did this man come from, but much more diplomatically put. And what was interesting was his response. And I add this only so we can see how essential it is to have regulatory mechanisms with all that that means in place. His response was he would not stop using that donor because it took every time. And I thought at that moment, that's one of the reasons why the Royal Commission made some of the recommendations that they made. So I add it here only because we have in common in Canada and the US, around the world, a set of issues. There is no other way other than perhaps the Human Fertilization and Embryology Authority, which manages, I think, quite well in the United Kingdom. We have to be focusing on that as lawyers, but also as feminists, as women whose bodies are used, if you will, in all of these procedures. So anyhow, I just add this because it concerns me greatly that we sometimes allow ourselves, put it the other way. If we focus on the interests of the child to be created, the creation of another human being, then perhaps we can find some consensus among ourselves how we move to the next step.
Thank you. Does anybody want to comment? Okay.
I just wanted to add something to what Jody said earlier about the impact that it has on donor-conceived people. So as part of my project, so one part was focused on insemination fraud. The other one was on large donor sibling groups. And we met with over 20 people who discovered that they had a large donor sibling group. And yes, some of them did say that they matched on dating apps, or they realized afterwards that they went to the same school or were in the same neighborhood. So chances for them to meet or have a relationship was not non-existent. And another thing that they said is that it made them feel like a mass product. So just also in terms of the way they perceive themselves, just knowing that I'm one of 500, maybe even more. So that also has an impact on them and how they perceive themselves. The fact that they know there's so many, but they don't know who their half siblings are, that's also like a source of distress for them. And those who invest a lot in those relationships, they feel a sense of grief for the fact that they will never be able to know all these people who they would love to know and form relationships with. And another, and maybe last point that came up was that as with insemination fraud, when they realized they have been conceived with the sperm of the doctor, in this case, they also questioned the motivations of the donor, like why did he give for so long? Why did he agree that so many people be conceived with his sperm? And then the same feeling of aversion, of feeling, oh my God, I'm also genetically related to someone who maybe had ulterior motives for giving his sperm. So all of these impacts have been documented in the project. So that's, yeah.
I just want to say these are Canadian problems. Like there are many cases of fertility fraud in Canada that have occurred, including Canadian doctors, Norm Barwin being one of them, but there's more that have occurred over time. And serial donors are a major question here too. There was a news story that broke in Quebec in June, 700 people plus being conceived with the genetic material of 3 men who are related to one another. One of whom has genetic disease in a relatively small area. And the government of Quebec has been very clear that they're going to vaguely move on this issue, but unclear what will come out of that. So these are like very alive and well issues in our jurisdictions that we consider. So it's not just happening in the States.